Hello, I'm Paul Steidler with the Lexington Institute, and I'm joined today by Ashley Baker, Executive Director of the Committee for Justice. President Trump has recently announced key antitrust appointments. He has named Gail Slater, an economic advisor to Senator J.D. Vance, to serve as the Assistant Attorney General for Antitrust in the Justice Department. The president has also announced he will name Andrew Ferguson, currently an FTC commissioner, to chair the FTC, something that does not require Senate approval. And the president will also nominate Mark Meader, a former aide to Senator Mike Lee and a prominent attorney, to be an FTC commissioner. He will replace, upon confirmation, Commissioner Lena Khan. Ashley is a nationally renowned expert on administrative law, examining issues at the intersection of the courts, regulation, and technology. She is the founder of the Alliance on Antitrust Coalition, has testified before the U.S. Senate on antitrust law, and has worked closely on efforts to confirm 3 U.S. Supreme Court nominees. Ashley, it is great to have you with us.
Thank you for having me, Paul.
From a broad policy standpoint, what are the characteristics of sound antitrust policy?
Yeah, sure. So from kind of more of a 30,000-foot level, without getting into too much detail here, what I would consider a sound antitrust policy is it's something that protects consumers by protecting what we refer to as the competitive process. So antitrust enforcement is used against conduct that is likely to harm consumers as a result to harm the competition. And then another characteristic of sound antitrust policy is what it doesn't do. So it shouldn't be used for things other than the antitrust laws itself. It should be used to achieve socioeconomic goals or other policies that are entirely unrelated to antitrust law.
And in general terms, how are the expected policies of the incoming Trump administration likely to be different than those of the Biden administration?
Well, I think more generally a lot different, both as policies, and we'll be hearing a different tune. After 4 years of experiencing the Biden administration in action through mostly the FTC, but also a bit the DOJ, I think there's a broader political demand for something different than Lena Khan's FTC and Cantor's DOJ. I think for the first time in a very long time, these are issues that are very much relevant to the American people because they have been hearing time after time over the past 4 years about certain FTC actions and how that has created a lot of business uncertainty, how it's hampered innovation. And they've heard more about that than they've heard about, supposed violations of antitrust law. So I think after that experience, we'll be seeing something quite a bit different, going kind of by each of the agencies, starting with the FTC. Incoming Chairman Andrew Ferguson, he actually, during his campaign for chairman, he floated a sort of document as a proposal of what his views are, what his policies would be, and what the FTC under him would do. And notably, he mentioned stopping Lena Khan's war on mergers. I would definitely categorize the current Biden FTC as being, above all else, just anti-merger in general. And Ferguson actually says in this document that most mergers benefit Americans and promote the movement of capital that fuels innovation. Focus FTC resources on the mergers that harm competition and hinder innovation while permitting mergers that keep capital flowing to innovators. And I think that's a very important point. And I think overall, we'll see antitrust enforcement as there should be antitrust enforcement. We'll stop seeing this broad anti-merger conduct that either stops mergers through litigation or prevents them from happening in the first place just through the threat. Which is another thing that the Khan FTC has continuously bragged about, is the number of mergers that they say have been stopped in the boardroom because they just didn't want to go through the process because that was too much of a threat. So moving on to the DOJ, we know a little bit less there, but one thing I would say is that Gail Slater, she has real knowledge of both antitrust law and of technology. And one way the Trump DOJ might be different from the Biden DOJ is Slater's probably unlikely to continue Jonathan Cantor's policy of threatening criminal prosecutions for previously civil violations of Section 2 of the Sherman Act. And more broadly speaking, I would say too that Gail Slater, she formerly worked at the FTC, and she's also she's worked for and represented companies too. And this means that she does understand the real world consequences imposed by these bureaucratic delays in the merger process and by this general regulatory uncertainty that has been created by the Biden administrations. So, at both agencies overall, I think we could see both strong antitrust enforcement when needed, combined with an equally aggressive focus on deregulation and maybe streamlining some processes and procedures in a way that makes a lot more sense and gives a lot more certainty to those parties who are merging.
Okay. And concerning antitrust enforcement, there has been recent discussion about combining the antitrust enforcement actions of the FTC into those of the U.S. Department of Justice as part of the DOJ effort. Is that a good idea?
Yes, I'd say so. And I think more generally, DOJ, or the Department of Government Efficiencies, it's a great opportunity for us to all think about the competition enforcement design of the two agencies, which share this dual overlapping authority. The merger clearance process, for example, it might as well be a coin toss between which agency is assigned to you as a merging party to review your merger. Actually, we discussed this at length in our brief in Axon versus FTC, which was a case the Supreme Court cited in 2023, and discussed how it's very unfair that if you're assigned the FTC and not the DOJ, you could potentially not have your case heard immediately by an Article 3 court. You could go to what they call Part 3 process, which is the in-house tribunal of the FTC. So that part of it is unfair. And there's also just the fact that it's inefficient. It's inefficient enforcement this way, that you have two agencies doing essentially what should be the same thing. And there are a lot of bureaucratic delays. There are a lot of inefficiencies there. So that effort, it could be streamlined. So DOJ, for example, could encourage Congress to pass the One Agency Act, which is a piece of legislation that's out there right now that's kind of been introduced a few times throughout the years, that was originally introduced by Senator Mike Lee, which would take the antitrust enforcement from the FTC and place it all under the DOJ, which wouldn't rid us of the FTC entirely. It would take the antitrust enforcement to the DOJ, house it all under there, under one department, under the DOJ, which does have enforcement powers and does represent the views of the United States. And the FTC would be left to enforce its consumer protection mandate where appropriate.
Okay. And what else is important to know at this time of transition?
Oh, there's a lot going on in antitrust right now. So one thing that I would highlight is kind of the tension right now that we have between the courts and the agencies, and how that could potentially play out down the road when it comes to some of the rulemaking actions of the FTC and some of the non-rulemaking. So, for example, this summer, the Supreme Court, in their decision of Loper Bright, they overturned the 40-year-old Chevron doctrine, under which the courts deferred to a federal agency's interpretation of ambiguous language in the laws that it administered. So federal judges are now going to rely on their own interpretation of ambiguous provisions, and this could apply from everything when it comes from the FTC's effective ban on non-competes on that rule and how that is interpreted, and whether or not they are correctly applying Section 6G of the FTC Act, to the FTC's interpretation of its own Section 5 policy statement from 2022, which I think it's fair to say goes far beyond what the statute says and what it intended. And then you also have this broader trend that I think we'll be seeing post-Loper Bright that applies to things that aren't explicitly rulemaking, but such as the merger guidelines. You know, the merger guidelines have been relied upon by judges, not because the judges really had to, but because the merger guidelines in the past, before the Biden administration kind of overturned them and rewrote them in a way that was not consistent with previous administrations, none of the previous administrations. You had these guidelines that were predictable and reliable and gave companies some sense of the rule of the road. So it gave something for judges that was actually useful to defer to when it came to antitrust litigation. Now that they, have kind of completely reversed course and overturned everything in the Biden administration, what use are those guidelines? And now that judges are not necessarily relying on agency interpretation as much, we'll see what happens there.
Thank you very much, Ashley. For additional information about Ashley Baker and the Committee for Justice, please visit committeeforjustice.org. And you can also find Ashley on X or Twitter at @AshleySays. That's at ANDASHLEYSAYS. Ashley, it's great to have you join us today. Thank you very much, and best wishes for a great new year.
Thank you for having me, Paul.